Hi, my name is Odin and I'm here representing Google Australia. Today I'm going to be talking to you about safe harbour provisions. Safe harbour provisions are a copyright protection concept which provides protection to content service providers. A good example of a content service provider is Facebook. Now, safe harbour provisions will allow Facebook certain protection against users uploading copyrighted material and protected and licensed content. Now, in Australia, these safe harbour provisions are not available to all content service providers, but they are available to internet service providers. The current legal problems related to safe harbour provisions under Australian law are that it currently only offers protection for internet service providers. There are also serious concerns about the protection of content creators' rights, and Australia not having safe harbour provisions has opened up Australian companies to copyright claims from third parties, making them liable for their users' content and actions. International Australian companies are also at a distinct disadvantage due to similar laws being in place internationally. Safe harbour provisions in Australia are a direct result of the United States of America copyright laws. Introduced in the Digital Millennium Copyright Act, these safe harbour provisions were aimed to strike a balance between content creators and content service providers. However, they have been slammed due to being skewed against content creators and providing near immunity to content service providers. This is due to poor drafting and the consequential evolution of case law and the internet. Australia in its legislative efforts is trying to avoid a similar situation from occurring. What law reforms have been proposed so far in relation to Australia's safe harbour provisions? Australian copyright law reform has proposed to extend the current safe harbour provisions to cover existing gaps in the legislation. This cover will extend to content service providers and non-public internet service providers that are not currently covered under Australian legislation. Why has the proposed law reform not been enacted? The Australian government wishes to consult with all stakeholders before enacting safe harbour provisions. This is mainly due to the resistance from content creators and rights owners who believe their content will not adequately be protected under the proposed framework. The Australian government is using existing safe harbour provisions in other countries as a basis to try and solve the problems with the proposed safe harbour provisions. The Australian government also wants to ensure that all objectives are achieved in relation to this legislation. The main goal is to stimulate the growth of the Australian digital economy. The main arguments for enacting the previously proposed safe harbour reforms are that it protects content service providers from copyright infringements caused by their users. It also allows a mechanism for content creators and licence holders to get protected content removed quickly and easily from the content service providers' sites. It allows Australian companies to compete equally with companies located overseas where there are similar laws in place, and it removes risk and uncertainty from business owners and Australian startup companies. However, the main arguments against the proposed safe harbour reforms are that it does not adequately protect content creators' rights. It can also lead to an increase in piracy with fewer options for enumeration. The policy behind the safe harbour reforms does not take into account the market for licensed online services, and it disincentivises content service providers to seek a licensed option for the hosting of protected materials. The proposed law reform to safe harbour provisions that will cover content service providers suits the interests of Google Australia completely. The proposed reforms provide Google Australia, and as an extension, Google Australia's subsidiaries, protection from copyright litigation being commenced due to user content. A possible policy solution that would suit Google and the stakeholders would be to encourage licensed options as part of the safe harbour provision mechanism. This would allow content creators adequate pay for their content. It would also provide content service providers protection from what their users upload. It may also be useful to provide legislative upper and lower limits for these license costs. The arguments in favour of this policy are that it provides a blended approach that balances the right of content creators and service providers. It also provides a mechanism for the reimbursement of content creators, while still providing adequate protection for content service providers. However, there could be arguments against this policy approach, as it could be costly for startup businesses, and the investigation and legislation writing could be very expensive for the taxpayers. So in conclusion, safe harbour provisions are a necessity for Australian businesses to grow digitally and internationally. Although the current proposed reforms are not ideal, they do provide a decent basis to benefit both content providers and creators in Australia.